Hey everybody, I am Hasib. I am a consumer attorney at Hasib Legal, which means I sue credit bureaus for inaccurately reporting things on people's credit report. What I wanted to talk about today and what a lot of people ask me about is how do I file lawsuits against credit bureaus for balances remaining after bankruptcy without filing a dispute first. Very specific way on how I do this, and I'm going to talk about the law that justifies this. So we know the Fair Credit Reporting Act. What we also know is how to file a Fair Credit Reporting Act lawsuit. What do we know? We know that there's an inaccuracy, there's a dispute sent, it comes back verified as accurate or doesn't get responded to at all, and then you could file a lawsuit because you are damaged. But in these cases that involve a bankruptcy, we do not file with a dispute. Why don't we do that? Is because the way we see it is bankruptcy information on a credit report is information that the credit bureau goes out and seeks, goes out and pays for. They do not need to be notified of this. We don't need to tell them. There are rules when it comes to debts and bankruptcy. And so the courts have made it so that they require the bureaus to go out and seek that information without us, the consumer, having to tell them. Think of it this way. In a case where I have a balance that I paid off, why do I send the bureau a dispute? Because they don't know that I paid it off. They rely on the furnisher to tell them that. If the furnisher is wrong, I need to be the one to tell them that they are wrong and they need to go and reinvestigate. But in a case involving a post-bankruptcy debt, meaning like balances on a credit report that remain after a bankruptcy is discharged or even dismissed, how do you go about getting that off the credit report and getting it updated to reflect how it should be reporting without having to go through the dispute process? You still can, but why does the Fair Credit Reporting Act treat this differently? It's because it's all about notice. They have notice in these types of cases already because they know about the bankruptcy and they know what is supposed to happen after a bankruptcy is filed and discharged. In the other types of cases, they don't know. They don't have knowledge of that. They don't know if you paid off that debt. You have to tell them. Or if the furnisher didn't tell them, the responsibility falls on you. But in these post-bankruptcy cases, which we're going to go through in a minute, you don't have to do that. This is why. So we're taking a look at this credit report, and I'm shown that there's a Chapter 7 bankruptcy, right? It was filed February 14, 2024, and it was discharged in May 2024. You can just tell that from this. I think this is a smart credit report. It's a 3-year bureau report, but you can tell from anything, annual credit report, identity IQ, however you want to take a look at it. It looks like the bankruptcy is not reporting on TransUnion at all. Now, there are a few reasons for this. One, either that TransUnion missed the bankruptcy entirely and didn't know that there's a bankruptcy, and in that case, it becomes a case because they have the obligation to go out and seek that information. So if they missed it, you have a claim against them under the Fair Credit Reporting Act. No dispute needed. You don't have to give them notice. They're supposed to go out and get it. They're supposed to go out and find out if the consumer filed for bankruptcy. They need to do this for every consumer. If they had, let's say they reported it, but reported it as dismissed, again, Fair Credit Reporting Act lawsuit, no dispute needed. And I'm going to go through in a minute why. But when we get a credit report with the bankruptcy on it, this is what we do. We look at the open date, February 14th, Valentine's Day 2024. Then we go on the credit report and we go through every single account to see every account that was opened before February 14th. Because what's the rule in bankruptcy? Pre-petition debts get discharged in bankruptcy, right? That's the rule. Now, in this case, let's see if that happened here. And I am going to go through all the accounts. And I happen to find one where the bankruptcy is reporting on basically the Experian account only, not the TransUnion and not the Equifax. But look at the balance here. TransUnion is not reporting a balance. Experian is not reporting a balance. This is a pre-petition account because it was open in June 2012 when we know the bankruptcy was in 2024. So it is... what we're thinking is, hey, maybe this was discharged. And what I would do is I would go into the bankruptcy public records, pull the bankruptcy petition to see if the debt was scheduled. It's not necessary that it needs to be scheduled because that's not the rule. The rule is all pre-petition debts and in no asset Chapter 7 bankruptcy are discharged whether scheduled or not. But my intuition is telling me, hey, maybe this was in the bankruptcy schedule. Because look, TransUnion is reporting $0, Experian is reporting $0. TransUnion not even reporting the bankruptcy, but it's clear that Wells Fargo probably told them, hey, there's a bankruptcy here. This account is $0 balance. But Equifax, they are reporting a $7,400 balance. This account is not owed on. I know this because I looked at the public records. The client told me there is no balance on this account, but Equifax is making it look like they owe $7,500 here. Now, what does this do? Let's go up to the summary section of the Smart Credit Report. Look at the balances across the accounts. 23,000 on TransUnion, 24,000 on Experian, and 35,000 on Equifax. Now that is that account. This is completely obliterating his debt to income ratio. This is making it look like he owes way more money than he actually does, but he doesn't because that account was discharged in his bankruptcy. It is not owed. They do not need to have that account on here. They missed the fact that it was included in bankruptcy. This fell through the cracks. They should have updated it, and we shouldn't even have to tell them because they themselves are reporting the bankruptcy. Well, what are our damages? If I go down to the inquiry section, I go to see, hey, did he apply for credit anytime after the bankruptcy discharge? And did they check the Equifax report? And I'm going to go to the client and say, hey, were you approved for this loan or denied? And I'm going to go out and seek the denial letter. And if I see that they reviewed the Equifax report with the inaccuracy on it and ask if it's denied, I would add that as an allegation that they were denied on the basis of that debt to income ratio or the balance that should have been wiped out. This makes for a Fair Credit Reporting Act case without a dispute because notice was already given by the fact that they themselves knew about the bankruptcy. They're reporting the bankruptcy. They know what bankruptcies do, and they know bankruptcies are supposed to suppress those accounts. That did not happen here. This is a Fair Credit Reporting Act case. What makes that possible? So this is the normal provision under the Fair Credit Reporting Act for which a lot of cases are filed. It's 1681I. What it means is this is a case where if something is disputed and it's not fixed in a credit file, enough information is provided and proof is attached, you either get something back verified as accurate or something not reinvestigated at all. This is what this provision talks about. This is what you sue under. And if you want to drag the furnisher into it, then you attach another claim called S2B, failure to reinvestigate. So this is the normal provision that people oftentimes use in a Fair Credit Reporting Act prima facie case where something's disputed, not fixed, and it's a actual inaccuracy that impacts somebody's ability to get credit. These things have to harm you. These things need to cause damage. I'm not talking about somebody's name misspelled. I'm not talking about an account number that's one digit off. I'm not talking about an open date that is 3 days after what the actual open date was. You're not going to get denied credit on that basis. You're going to get denied credit because there are balances owed or somebody else's accounts reporting on your file. Stuff like that. Stuff that cause actual inaccuracy. If that's not happening, forget about the Fair Credit Reporting Act. Forget about standing. You need standing to bring a federal lawsuit. If that's not happening, you need an injury in fact. If that's not happening, you can't bring a case. So this is the normal provision. Forget about this in these post-bankruptcy cases because the actual provision of the FCRA that we're looking at is 1681E, particularly right here, B, 1681EB, which says whenever accuracy of a credit report, whenever a consumer reporting agency prepares a consumer report, it shall follow reasonable procedures to assure maximum possible accuracy of the information concerning the individual about whom the report relates. What does that say? It means, hey, the bureaus are reporting the bankruptcy. Now they need to do everything they can to assure maximum possible accuracy of the trade lines associated with that bankruptcy. Meaning if there's a bankruptcy, they know what a bankruptcy does. They know that it zeroes out accounts. They know that what's supposed to happen is everything should get zeroed out and then a status should attach which says reasonable, which should say Chapter 7 bankruptcy or Chapter 13 bankruptcy, whatever it may be. If that's not happening and accounts get missed, you have this claim where, hey, you credit bureau, you didn't have these reasonable procedures in place. That's what this claim is all about. Not a dispute that's not fixed, but EB, 1681 EB, not 1681I, 1681 EB. You don't have reasonable procedures. If you did, you would not have reported that additional $7,500 balance onto this gentleman's report. That is what we're alleging. So what is the basis of that? Why do we think that the procedure should be this bankruptcy, which leads to a zero out of the trade line, or this discharge status that are supposed to apply to the report? What is the law that tells us that? Well, case law. We rely on this case, White versus Experian, which was an approval order back many, many years ago. And this is what this approval order says. It says this is basically a case about a class action settlement from an order from the U.S. District Court for the Central District of California. It consolidated several lawsuits related to this against all the major credit bureaus, Experian, Equifax, TransUnion. So even though this says Experian, this isn't just Experian. It's like related cases too. So this is what the court says. Well, the plaintiff alleged that the bureaus violated the FCRA by inaccurately reporting pre-bankruptcy debts on the credit files of consumers who had received a Chapter 7 bankruptcy discharge. The plaintiffs argued that the bureaus were too reliant on creditors to self-report discharge statuses rather than proactively coding them as discharged. Like if Wells Fargo was relied on here and they accurately reported the $0 balance, or if they reported the $7,500 balance, Equifax could not have just relied on what Wells Fargo was reporting by that $7,500. Sometimes these bureaus are too reliant on it. That's what this is saying. So the bureaus have this obligation to comply with 1681 EB to go out and zero out those balances when they know there's a bankruptcy, because they know the general rule. So after a consumer receives a Chapter 7 bankruptcy discharge, debts that were wiped out should be reporting as discharge on their credit report. The bureaus were failing to do this reliably, which is the result in this lawsuit, White versus Experian. This harmed consumers' credit worthiness even after their debts were legally eliminated. So what this order in California required, and now it's basically law, the bureaus must go back through existing credit files and apply what the order calls agreed bankruptcy coding. Right here. Agreed bankruptcy coding. The bureaus must go back and apply this, making pre-bankruptcy debts as included / discharged in bankruptcy, zeroing out balances and preventing further derogatory updates to those accounts. There was prospective changes, which going forward within 60 days of receiving a notice of a Chapter 7 discharge, the bureaus must update all qualifying pre-bankruptcy petition trade lines, judgments, and collections accounts in the same manner. So, what does that say? So after 60 days after that, getting that discharge order, discharge information that they actually got here, they knew this, they got this information from public record, LexisNexis, 60 days. So by April 2024, what they should have done is go out and zero out those accounts. They didn't do that on this Wells Fargo account. So this violates the White order. The White order basically tells us, hey, what is compliance with 1681 EB? All this stuff should be in compliance. The order lays out detailed technical rules for different types of accounts, civil judgments, installments, mortgage loans, revolving credit lines, and collection accounts, specifying which accounts qualify and how they should be coded. For our purposes, that Wells Fargo account doesn't meet any of those definitions, just a normal pre-petition debt. Certain debts are excluded from the automatic bankruptcy coding. That could be like student loans, child support, alimony, tax liens, and governmental fines. All debts are typically non-dischargeable in bankruptcy. Implementation deadline, they were supposed to have done this by, I think it was 2009, sometime in 2009. Yeah, March 31st, 2009. So what are we in now? 2026. And now they should have implemented this, and things still fall through the crack as they did here. So now we have the 1681 EB claim. The legal effect of that White order was that the court certified a settlement class of all consumers with the Chapter 7 bankruptcy discharge. And now they have these new procedures to implement to stay in compliance with 1681 EB. In short, the order forced Experian, Equifax, and TransUnion to overhaul how they handle credit reporting for Chapter 7 bankruptcy consumers, requiring them to proactively co-discharge debts as such rather than waiting for creditors to do so. And that is the basis of why we're able to bring these without a dispute. This isn't a dispute reinvestigation claim. This is a procedures claim. Experian, Equifax, TransUnion needed reasonable procedures to assure maximum possible accuracy. That didn't happen here, and that's the basis of this lawsuit. If this happened to one of your clients, you know who to reach out to. This is all we do.